All right, this is Somnia Inc. and Resource Anesthesiologist Associates of Michigan PC versus Capital Area Anesthesia PC et al. Docket number 21-35CB. This is the time set for hearing on the plaintiff's motion for partial summary disposition. And I'll take attorney appearances, please.
Thank you. Good afternoon, Your Honor. Roger Myers, appearing on behalf of the plaintiffs, and with me I have Monica Batsford today.
Good afternoon, Your Honor. Stephanie Jones on behalf of the defendants, and I also have my colleague Chirag Patel with me as well.
Thank you very much. So this is your motion, Mr. Myers. You can go ahead whenever you're ready.
Thank you, Your Honor. This is, I think, a very straightforward motion, so I'm not going to belabor it. We have a claim in this case that the defendants tortiously interfered with our anesthesia services agreement with McLaren Greater Lansing. Now, that agreement has an integration clause that's found at section 6.8 of the agreement, and it has a no other representations clause that's found at section 6.23. Nowhere in the agreement, though, is there any word, not a single word, about hiring CAPC or any of its personnel. But the defendants here want to argue as a defense in this case that MGL had a right to terminate the agreement because a necessary condition wasn't met, namely a condition that plaintiffs hire CAPC personnel, or at least some percentage of them. They haven't pointed anything in the agreement that says that, but that's the theory of their defense, that there was no breach of contract because MGL was allowed to terminate because this condition wasn't met. And the problem is that is a defense that is 100% foreclosed by black letter Michigan law. Even a party can't add a new unwritten condition to a fully integrated agreement. Defendants weren't even parties to this agreement. They certainly can't do something that a party itself can't do. So the defense fails on the pleadings under MCR 2.116C9. No discovery is ever going to change that. It doesn't matter what MGL subjectively thought. It's not in the agreement. They can't point to anything in the agreement, so discovery is completely irrelevant. But discovery on this topic, deposing MGL people, for example, or deposing our folks on what did they talk about with respect to hiring CAPC personnel, that would be burdensome. It's going to be time consuming. It's going to be expensive. And at the end of the day, none of it will ever be admissible, and none of it can change anything because the defense fails at the outset on the pleadings. And the whole point of a C9 motion, and this is the Slater case, is to get rid of things early in the case without having to go through the costs of discovery. And that is particularly true here in business court, where the idea is to streamline these disputes. So that's why we brought this motion. It is dispositive of that defense in its entirety. I want to talk about what CAPC said in its opposition brief and why none of that changes the outcome here. First, CAPC has absolutely conceded that it does intend to pursue this defense. So there's no question about that. They suggest that this is a pleading deficiency issue and that we should have asked them to clarify. Respectfully, Your Honor, that would just be wasting time. We understood what they're saying is their defense. They have acknowledged it in their opposition, and what we did is moved on the merits. So we pointed out solely that their answer was sort of vague on this point, but we understood what they were going after, and either it's in the pleading or it hasn't been pled and it's been waived. So it really doesn't help to say that they should clarify it. I think we all know what they're talking about. CAPC has conceded in its opposition brief that there are no words in this agreement that set forth the condition that they claim exists. Now, they've had the agreement for about 6 months. We sent it to them along with, or shortly after we filed the case. They have certainly had it for the 5 weeks this motion has been pending since we filed it. And if there were words in the agreement that set forth this condition, they would have found them and they would have presented them to the court. But they haven't done that. And it's their obligation to show not just some speculation about a condition, but to actually show that it's in the agreement in response to this motion. They haven't carried that burden. They've got some other grounds that they attempt to oppose the motion on. First is one that's just procedurally completely improper, and that's the reliance on interrogatory responses and deposition testimony from the arbitration. It's a C9 motion, Judge. They can't bring in anything that's outside of the pleadings. They did this on roughly 6 different pages of their opposition brief. I think the court would be entitled to strike it. Certainly, the court should just disregard that material. But I also just want to add, none of it would change anything, even if it was properly before the court, because it doesn't matter what MGL's CEO, Kirk Ray, thought subjectively was going to happen. The agreement doesn't contain the obligation. We don't look outside of the 4 corners of the agreement. That's the end of that. They emphasize that they really want discovery, and they suggest that this is some sort of an underhanded or an improper effort to preclude discovery. Again, that's just the whole point of having this procedural mechanism, is to avoid inefficient, unnecessary discovery. So it's not inappropriate to short circuit attempts to take discovery that can never change the arc of the case. There's a fraudulent inducement exception that they try to invoke and say, well, integration clause can't stop or can't stop a claim or an argument based on fraudulent inducement. Well, there's a few different problems with that, Your Honor. First, absolutely without question, fraudulent inducement is an affirmative defense that has to be pled with specificity. And that's the Elvenshine case. They didn't say a word in their answer or their affirmative defenses about fraud. So they haven't pled it. That one is absolutely waived. But again, even if it were not waived, they're not really saying that they have a defense based on fraudulent inducement. They're saying, Judge, we need to take discovery to figure out if just maybe the plaintiffs defrauded MGL. So they don't even have, set aside particularity, they don't even have grounds to allege fraud in the first place because they don't have any facts that tell them if it happened or not. They're just speculating that maybe if they ask enough questions, they can churn up a fraud. That's not the way this works. They can't plead it. They haven't pleaded. And so that exception doesn't give them any basis to get around the integration clause. Then they turn to ambiguity. And they say, well, if you read enough provisions, which are scattered over several pages, if you read enough provisions, then it creates this question mark about maybe whether there was some obligation or not. Again, that's not the way that you establish an ambiguity. You take actual language from the agreement and you say, here's what the language says, and here's what it means. And I understand that the other side has a different view about what the language means. There are 2 reasonable interpretations here, and we have to get to a jury to figure out which is the right interpretation. That's how we do ambiguity. You don't just take several pages worth of material, characterize but not attach it, and then say, well, there might be an ambiguous meaning here. And again, setting aside just that they did it, that they did it in the wrong way, that you can't do it that way. When you look at what they go on to say, they say, at the very least, there might have been a condition here either to retain or to make significant efforts to retain their people. So even if you take all of the things they try to put together, they still can't even say what the condition that they're trying to create is. That's not an ambiguity. It's not a basis to go outside of the 4 corners of the contract. The last thing I want to say about that is, or about their opposition, is they say what they really want to do is add non-contradictory supplemental terms. And the case law allows them to do that. Again, that's not what the case law says. The case law says that if you've got an obvious deficiency, an obviously incomplete agreement, then you can supply a missing term, notwithstanding an integration clause. We don't have an obviously incomplete agreement here. There are dozens of pages of detail, and what they're trying to do is add an entirely new obligation to that agreement. The case law says you can't do that. It does not say that you can. And this notion that it's non-contradictory, that just doesn't work. To add a condition that is not written into that agreement is going to contradict the integration clause that says the entire agreement is right here. There is nothing else. And it's certainly going to contradict no other representations clause that says there isn't anything else. And these are sophisticated parties who had legal counsel, who negotiated this agreement. There's just no basis to say, well, they forgot this one really important thing and we're going to supply that as a missing term. So they're trying to contradict the written agreement. None of those arguments hold any water whatsoever. So that, unless the court has any questions, that's my argument as to the merits of the defense. We did ask for costs on this one, Your Honor, and the reason is we told them this is what we're going to move on. We have this position. Here's our case law. This is the black letter law of Michigan, and you can't bring in extrinsic evidence. And if you have facts or law to say we're wrong, to support that you're able to do this, please tell us. Otherwise, you should stipulate to dismiss this defense so we don't have to bring this motion. And they refused. And that's, if they're going to take that position, then they have to have a non-frivolous defense to put forward as to why they get to maintain this. And they haven't done so, Your Honor. So again, unless the court has any questions, I would ask the motion be granted in full, that the defense be dismissed, and that the court award our costs for having to bring this motion.
All right, thank you. Ms. Jones?
Thank you, Your Honor. Your Honor, I have been admittedly confused by this motion. First, when Mr. Myers brought it to my attention, once it was filed, and even probably more so now after hearing what Mr. Myers has said today. In their motion, they request that this court, and I quote, summarily dispose with prejudice any defense predicated on alleged extrinsic representations, promises, or conditions not set forth in the fully integrated agreement. All I've seen from argument and conversations with opposing counsel and the motion is that, hey, the agreement has an integration clause, so you can't talk about anything else except what's in there. Even today, Mr. Myers said there's an integration clause, and I believe I quote, and it was the defenses, they carried the burden to show that there was text in the contract that said that CAPC was required to be retained. Never once have we said the contract on its face doesn't say what it says. Never once did we say that the integration clause doesn't exist and this is a fake integration clause. We acknowledge what the text of the contract says. We acknowledge that there's an integration clause, but that doesn't prevent us from exploring, and I quote, any defense predicated on that alleged extrinsic representations. We have on very, very good authority, both fact and law, that RAM and or Somnia made overt promises, either pre-contract negotiations, throughout after the contract was signed, that led up to the breach, all of which is not only directly relevant to potential affirmative defenses, but the actual defense of the case. They have to be able to prove that CAPC, my client, caused the breach. If it turns out that both McLaren and Somnia were under a mutual mistaken, understanding that CAPC was going to be retained, that means it wasn't us that caused the breach, that they had that mutual understanding. If the text of the contract, as we set forth in our brief, meant something to both McLaren and to Somnia and or RAM that was different than on the face, we should be entitled to understand what that is. That is directly relevant to being able to prove our defense. So all I hear from this motion is, Judge, there's an integration clause, so it is what it is, and the defense shouldn't be entitled to discover anything leading up to what the decision makers were thinking at the time, why McLaren ultimately terminated the contract, what Somnia and or RAM was able or unable to perform under the contract. That's also become an issue, whether Somnia and or RAM could even retain providers to provide the anesthesiology services without CAPC. All of that is germane to just be able to defend our case, to be able to establish any number of the defenses. There's been some dodging and diving, through this motion about pleadings and defenses, and that this is overly simplified. I couldn't disagree more. This is the heart of our case. The ability to say, and I think I would be remiss to not remind the court that CAPC had nothing to do with the contract. This is a third-party contract. We're not a party to the contract that's coming in and saying, it's actually your fault. We thought this. We're a third party.
Can I just interrupt you there to ask you something? I recognize
Of course.
that's not lost on me, that this is a third-party contract that your client's not a party to. But, but with some of the defenses that you're speaking of, wouldn't they still be required to be pled as an affirmative defense in your answer and affirmative defenses?
No, I don't think so. I mean, substantial cause of the breach is an element of the claim itself. So that's not necessarily an affirmative defense. It's just simply a defense to the claim.
Yeah, causation, I totally get that. But, you're talking about things like, fraudulent inducement was one of the items mentioned in your brief. I mean, wouldn't that have to be pled as an affirmative defense? And I realize it's a strange-ish situation because one of the elements of tortious interference is breach of contract, that the contract was breached. Do you have to assert affirmative defenses that would go to the breach of the contract when you're not actually in a breach of contract action per se? Or, what's your position on that?
I think right now my position is this motion was brought before any documents had even been exchanged. Now we've gotten through production. Now we've seen more documents. We've gotten, we've responded to requests to admit. There's been very substantial document production and written discovery that's done. So we have the benefit of a little bit more than we did when the motion was first filed. And I think we acknowledge that you have to plead fraud with specificity. But when we are behind closed doors and we don't know the facts, how in good faith can we bring that? I mean, we believe that there were fraudulent statements made to us when trying to negotiate the contracts, but whether there were fraudulent statements or misrepresentations about their ability to run a residency program, their ability to take over the program generally, or to provide the services in full as outlined in the contract, that's something that we need discovery on. So whether or not we need to plead it or not, I think is still premature. And I think we need to be able to, because those issues are intertwined in both whether we need to plead it with specificity and the defense generally to the elements of tortious interference.
Okay, thank you. And I'm sorry for interrupting you. If you have more to say, go ahead.
No, Judge, I think generally speaking, our position is that an integration clause itself should not foreclose the defense from discovering information that has direct bearing on our ability to defend this case. It's premature at this point. I think, my colleague who's on the call today had a call with opposing counsel and even suggested if we were through discovery, we may be able to agree to some of the stuff that's brought up here, but we don't know. It's premature. And we're not trying to waste the court's time, spend unnecessary resources and time on discovering things that are not relevant. But this is critically germane to the case. And this case should be resolved on the merits. It should be resolved after understanding what happened between closed doors, not in the presence of us and not with anything to do with us, and whether that has a bearing on our defense, whether we had anything to do with the breach, whether it was a breach, whether the parties were under a mistaken assumption of facts, whether the on its face, the conditions of the contract have latent ambiguities. After receiving plaintiff's reply brief, we looked into more case law, and in Woodworth Trust 196 Michigan App 326 talks specifically about discovery of extrinsic facts with latent ambiguities when even there is an integration clause in a contract, and that's entirely appropriate. If there's a latent ambiguity that requires some sort of interpretation because the parties were under a different understanding than CAPC could ever understand, or know because they weren't party to it, then we should be able to discover that. And I just think this motion just seems entirely premature, and to foreclose. I think another portion of what's important to understand about this motion is that when we spoke with opposing counsel prior to the motion being filed, I said, look, I'll look into this and see if this is something we can agree to. But, I don't think we could ever agree to foreclose discovery on things that would be relevant to a causation, defense. And they said, no, that's exactly what we are trying to do. We're trying to foreclose you from getting discovery on what was said before the contract was signed between the parties, and then even after the contract was signed and up until, and even I guess potentially after the alleged breach or the termination of the contract. So we said, how can we agree to that? That's incredibly germane to what the actual issues at the heart of this case are. Why would we ever foreclose ourselves the opportunity to discover what was being said and why people did what they did, which put us in the situation that we're in? And then they filed the brief. So, I think with that, Judge, our position is that this is premature. We should be entitled to seek discovery on issues that allow us to establish our substantive defenses, whether they're affirmative defenses, whether they're defenses to the claims themselves. We're entitled to that discovery, and the motion should be denied. Thank you, Judge.
I just have another question. Doesn't your causation issue sort of trump the breach issue? Because even if there was fraud in the inducement, what really trumps the whole thing for purposes of tortious interference was that what caused McLaren to terminate the contract? Isn't that the case?
I believe so. You could say that for sure if that was the case. I have serious concerns about the level of cooperation between McLaren and Somnia now that they've settled their underlying case, and whether things are going to change when we cross-examine them about that, I don't know. And so I don't want to foreclose the opportunity to be able to defend the case on the breach itself by saying, oh yes, it strictly lies within the causation.
Okay, thank you. Mr. Myers?
Thank you, Your Honor. I'd like to start with the prior question that you asked. Aren't these affirmative defenses that you have to plead? They 100% absolutely are. Fraud is a classic affirmative defense. Again, I'd refer the court to the Ovenshine case, just came out of the Court of Appeals within the last year. And it was an extensive recitation of pleading fraud as an affirmative defense.
Yeah, but there's no doubt in my mind that fraud is an affirmative defense. None, zero. But here, this is not a breach of contract action. It's a tortious interference with a contract action, one of the elements of which is that the contract was breached. So is it still an affirmative defense in that context?
And I would answer that it is, Your Honor, and here's why. And this goes to the second question that you asked. And I think it's helpful to tease these apart. There's a difference between CAPC being able to say, for example, we didn't cause the breach because MGL made its decision for other reasons. That's not negating the breach. That's trying to negate causation. But when you try to assert fraudulent inducement in the manner in which they say there's a condition here, and there's no breach at all because MGL was entitled to cancel. Well, now that's using it in the same sense in which it's an affirmative defense in a contract action. And what we're saying is you can't come in and say MGL was entitled to breach, whether it subjectively was mistaken or for any other reason. If it's not in the contract, then they're bound to what the contract required. And Your Honor, also mistake is this is a new one that we've heard today now. Mistake is an affirmative defense as well. And I didn't get a chance to respond to it because we just heard it. But mistake goes back to the Peerless case. The contract says we're gonna send the shipping on a ship called Peerless, and one party thinks they mean one ship, and the other party thinks they mean another ship because they both have the same name. It still goes back to something that's in the contract, a mistake in the contract. We don't have anything like that here at all, Your Honor. But as I was listening to Ms. Jones talk about it, she mentioned several things, but I wrote down that they have substantial evidence of or good authority of extrinsic representations. That's exactly the sort of thing that the integration clause keeps out of this dispute and should not allow this to be something that ends up in discovery here. It's not premature. It's not inappropriate to cut off discovery. Every motion to dismiss, whether it's a complaint or a defense at the pleadings, is going to cut off discovery on that topic if it's granted. It's just not inappropriate when the thing that you want to take discovery on is foreclosed. Again, happy to answer any other questions the court has, but otherwise, I just ask the court to grant the motion.
Okay, thank you. Well, I had to smile when the plaintiff said that this is straightforward, first thing out of his mouth, because I don't think this is as straightforward as the plaintiff suggests. First, for clarity, this is a partial motion for summary disposition that's directed only at the tortious interference with the contract claim, and it's directed only at one defense of that claim. And that one defense is described by the plaintiffs, not the defendants, but the plaintiffs in their moving papers as follows. The defendants claim that the contract between McLaren and RAM, and I'm just gonna, for the sake of the record, that's the plaintiff, RAM, was not breached because McLaren was entitled to cancel the contract if RAM couldn't fulfill certain conditions and obligations of the contract, specifically to hire the defendant, CAPC, CAAPC providers. The plaintiff's position that any such condition or obligation would have to be contained in the contract because the contract's fully integrated, and the defendant's failure to identify any such provision in the contract makes this defense legally unsustainable. So that's the issue that the plaintiff brought before the court in this motion. It is a C9 motion, and a C9 motion attacks the legal sufficiency of an answer or defense. And it's tested by the pleadings alone, and in a case such as this one, the terms of the contract that's at issue. The standard is whether the defense is so clearly untenable that as a matter of law, no factual development could possibly deny the plaintiff's right to recovery. So my first question on this case was, where is this defense? Because you can't make up the other side's defense and then claim that it's legally deficient. The plaintiffs attached the defendant's affirmative defenses to their brief, but they didn't attach the answer to the complaint. And I don't think, if you're just denying an element of the claim, in other words, there was no breach of the contract, nothing more, no fraud, nothing special. If you're just denying there was a breach of the contract, then I don't think that's actually an affirmative defense. But in any event, the plaintiffs make no mention of whether they attach the affirmative defenses, but make no mention of whether it was effectively denied in the answer to the complaint, if it was not a defense that required an affirmative defense. So it was rather confusing, but the defendants came along and sort of sorted out this entire conundrum by acknowledging that that is their defense and putting forth 4 ways that the integration clause would not make their defense legally untenable. The first way, they say, is that the contract is void because of fraudulent inducement. I think that's unconvincing because fraud in the inducement would be an affirmative defense, and it was not pled as an affirmative defense. The second way is impossibility of performance. That would also be an affirmative defense, and it was not pled as an affirmative defense. The third way is the defendants say that the parties agreed to supplement non-contradictory terms. But that doesn't work either because of section 6.8 in the contract, which says, somewhat paraphrasing here or leaving out unimportant parts, this agreement is the entire understanding and agreement of the parties regarding its subject matter and supersedes any prior oral or written agreements, representations, understandings, or discussions among the parties with respect to such subject matter, end quote. It also doesn't work because of section 6.23, which says each party represents that no representation or promise not expressly contained in this agreement has been made by the other party, and B, this agreement is not being entered into on the basis of or in reliance on any promise or representation expressed or implied other than such as are set forth expressly in this agreement. End of that quote. So in other words, the defendants would just ignore the integration clauses of a fully integrated contract, and I can't do that. But the last basis for the defense that the defendants give is that the very terms of the contract, without going outside of it, suggest that the defendant providers were needed to be retained in order to fulfill the contractual requirements, or they also suggest maybe the contract is ambiguous in that regard. But in any event, if the contract actually suggested or required or was agreeing that the defendant providers were necessary to be retained, and that wasn't going to happen, then the contract could have been terminated, which would be for reasons other than the defendant's alleged tortious interference. The plaintiffs say that those contractual provisions that the defendants pulled out of the contract for their fourth argument here don't actually say what the defendants claim they say, and that the contract's being misstated. The plaintiffs also suggest that the defendants should have attached the full contract, but this is the plaintiff's motion, and the plaintiff didn't attach the full contract. How can I look at a contract and say that a defense that the contract was not breached is legally untenable and no factual development can change that when I haven't been given the contract? I can't. Now, I know that the plaintiffs suggest in a footnote that if the contract is needed, it can be provided. But let me just suggest that if I need to see a confidential contract, I'm not going to ex parte ask for it. There really should have been a communication between counsel and an agreement that a judge's copy of the contract could be provided to me in a sealed envelope marked confidential so that I could properly assess a C9 motion, which would require reading the entire contract. Instead, I have the parts pulled out by the defendants, and I think they've addressed a number of contractual provisions that address the hiring of providers to provide anesthesia services. And they also mention another part of the contract that I don't believe I had, which is a for-cause contract termination provision. So all I can say is that I do agree that it would be very beneficial if we could narrow matters in this case. And that is something I'd be more than happy to do. But with what I have here before me today, and with discovery not being complete, and with the standard of a C9 motion in mind, that I would have to find no factual development could legally justify this defense, I am denying without prejudice the plaintiff's motion for partial summary disposition. I can say at the very least, factual development is needed to determine whether RAM could have met the provider provisions of the contract and whether that was in fact the reason that the contract was terminated rather than a breach. Yes, if that was in fact the reason the contract was terminated, rather than because of any alleged comments or remarks or statements that the defendants made. And for those reasons, I am denying the plaintiff's motion for partial summary disposition.
Thank you, Your Honor.
Thank you. And someone will submit an order, probably Ms. Jones, or?
Yes, we'll do. Thank you.
Okay, thank you.
Thank you.
Your Honor.
Okay, looks like everybody's connected now. The Zoom instructions did request that people change their names for the hearing, but their screen names. I have someone in the waiting room named Amy, and I don't let just anyone into hearings unless someone can help me out and know who that is.
That is the plaintiff, Your Honor.
Oh, okay. I'll let her in.
Thank you.
Okay, so I've now let everybody in that was in the waiting room. I realize there are some parties here. Some of you have already muted yourself. I would just ask you, if you're a party, not an attorney with a speaking role, if you would mute yourself. It helps so that we don't have background noise and interference, etc. And I apologize in advance for my unintentional mispronunciation of any names in this case, but this is Mi Chun Yi versus Formosa, Michigan, LLC et al., docket number 20-597CB. And I have this afternoon actually 4 motions that are scheduled. There is the plaintiff's motion to compel, which we will get to later. There's the plaintiff's motion for leave to file a second amended complaint, which we will get to later. And then there's the 2 remaining motions, which are really mirror images of each other. So I'm just going to hear them together as one, and that is the defendant's motion to confirm sale of Formosa assets and the plaintiff's motion to uphold voting rights. And in that regard, if I could then proceed to have the attorney's appearances for the record, please.
Mark Zietlow on behalf of plaintiff, Your Honor.
Alice Pye on behalf of plaintiff, Your Honor.
James R. Giddings on behalf of defendants Formosa, Chow, Juan, and Chu Chu Wang's Harja, I hope.
All right, I understand. Okay, I'll start with you, Mr. Giddings, then, your motion to confirm sale of assets. And then as I indicated, I'll hear from the other side because their motion to uphold voting rights is the same issue, just from their perspective.
Basically the same issue. The operating agreement in this matter is very clear. The statute that applies to this is equally clear. The power to vote on matters of this type are by majority vote. And as a matter of fact, the operating agreement specifically says, I don't know, did I lose somebody or something? I'm not saying, am I still there?
Yeah. Yeah, you're fine.
Okay, I'm not, I see nothing on my screen, but I'm still functioning here.
You are. Maybe your screen went to sleep. I don't know. And do you want to move
No,
your mouse?
that's fine. I just,
Okay.
but the decision to sell this property actually was made at 2 meetings. The first one was on March 11, 2021. The members at that time, a majority, held a meeting. The meeting was held open for plaintiff Ye, was held for 30 minutes. She did not appear. Apparently, she said she tried to get into the meeting and was not allowed in. That is not the understanding of the defendants, but in any case, because of that issue, the meeting was rescheduled for April 8th. In fact, the plaintiff did participate in that meeting, and Alice Pye appeared in that meeting on behalf of one of the bidders. In fact, I moved to ask at some point here if she is representing the bidder in this proceeding. But in any case, that meeting was held and there was discussion and a decision was passed by the members, a majority of the ownership interests, to sell the assets of Formosa. I believe it's fair to say that Ms. Ye, initially she voted against it. I think ultimately she did not vote. But in any case, the statute is clear. 4501 talks about what members can do. And it says, unless otherwise provided in the operating agreement, the sale, lease, exchange, lease, or transfer of all or substantially all of the assets of a limited liability company may be authorized only by a vote of the members entitled to vote. And then subsection 8 under MCL 450.4502 says that it's by holders of a majority interest. It's not unanimous. And that is exactly what the operating agreement here provides for in sections 6.1 and 6.2. A majority decides. I might add that there have been arguments made by counsel that somehow other considerations should weigh on this vote. That, am I still participating?
You are.
Oh, okay. Can I be seen or no?
I can see you fine. I don't have any
Okay,
problems.
all right. I am not seeing here. But in any case, this is what 4502 MCL, again, 450.4502. Unless the vote of a greater percentage of the voting interest of members is required by this act, by the articles of our organization, or an operating agreement, a vote of a majority and interest of the members entitled to vote is required to approve any matter submitted for a vote of the members. And that includes the sale of assets. So technically, under Michigan law, other exceptions as suggested by the plaintiff here are not permissible. So we think that part of it is pretty clear under the operating agreement, under these statutes. And so we're just asking the court to give these folks the permission to go ahead and sell. I think I would add to this the fact that for 27 months, my clients, along with Formosa, have been operating this business. The plaintiff walked out of this business 27 months ago over a dispute. She claims a debt is owed to her, but in any case, she walked away. And the plaintiffs have carried this business through hard work for that 27-month period. And but for their efforts, there would be no business today. The business, due to the pandemic, generate enough income in order to pay its ongoing expenses. As luck would have it, recently they got a government grant of $53,000, I believe $57,000, which amount has been banked and not spent for any purpose. But the reality is it cannot generate enough money to keep operating. It could operate for a while. And their choice is, as the majority owners of this enterprise, is to sell the business. We have a bidder who's prepared to come forward and pay $91,500. And from that, there are about $40,000 in current debts, which would leave all the members roughly $50,000 to divide up. And we're not suggesting how that should be done. In fact, we suggest that any of those funds should be placed in escrow and divided pretty much in accordance with the agreement of the parties, with the exception that we think the debts that are outstanding ought to be paid. Essentially, that's our position, Your Honor. Thank you.
All right, Mr. Zitlow or Ms. Pye, whoever's responding. for the plaintiff?
Your Honor, I will proceed first. This is Mark Zietlow on behalf of the plaintiff, Amy. With all due respect to Mr. Giddings, he has contradicted his position numerous times throughout this litigation. We have submitted as exhibits to our supplemental brief 2 emails from Mr. Giddings. I will quote from them. One email specifically says, quote, "I spoke to Mark this afternoon and he reminded me of paragraph 7.3 of the operating agreement, which gives your client, the plaintiff, the right to approve any sale of the business. We agree with that," unquote. In another email, he later said, quote, "Again, I agree that your client must consent to the sale," unquote. Mr. Giddings obviously agreed that 7.3 of the operating agreement applies. He now has contradicted himself in an obvious conflict of interest and represents to this company, to the company and to the minority owner, that it is not 7.3 that applies, but something else. Your Honor, we've dealt with this problem, this oppression, this fraudulent treatment, this deception, time and time again, and it's time to stop. Not only that, Mr. Giddings inappropriately refers to MCL. Both of the provisions that he cites clearly carve out exceptions that point to the operating agreement as the operative document. Your Honor, we ask that you provide a reasonable interpretation of the operating agreement as started in the business plan and require that plaintiff's consent must be given before any sale. Mr. Giddings cites both of these statutes that say that, and I quote, "unless otherwise provided in an operating agreement." That's one statute, and certainly we will point to the operating agreement to the contrary. His other statute says, "unless the vote of a greater percentage of the voting interest of the members is required in an operating agreement." Again, we will show that the operating agreement in 7.3 clearly requires a unanimous consent of all members in order to proceed with a sale or any other condition that is a serious condition for the company, such as a change in its operations, a dissolution, a change in anything that has to do with affecting the company's business, has to have approval by all members, unanimous consent. All we are asking is that bidding be allowed. We have provided Mr. Giddings with information that another bidder is willing to go up to $100,000 on the exact same conditions that Mr. Giddings accepted before. And why not do it? Why not get more? And Mr. Giddings has never been able to answer that question. I want to step back and look at the operating agreement and before that, even the business plan, which was the foundation for the entire investment. Please understand, Your Honor, the plaintiff is an immigrant from Taiwan. She came to the United States in search of the American dream. Instead, this has turned out to be a nightmare. Plaintiff wanted to start a business in the Lansing area. She met Mr. David Wan, who Mr. Giddings said he represents, in another conflict of interest situation. And he had 12 years of experience in restaurant business, including management. He prepared a business plan for her with the goal to ultimately her to operate the business. It was going to be her business. He predicted over $250,000 in net profit. It was going to be a sustaining business. The business plan showed plaintiff would be the owner president. He would be the general manager. The business plan said that financial reports would be prepared, including weekly cost reports showing gross profit margins, reports detailing cash expenditures, payments of checks and accounts payable. These were all promised. None, not a single one, has ever been provided. Most importantly, Your Honor, and what we feel is very instrumental in this hearing today, is what Mr. Yuan represented in the business plan. he clearly said the restaurant may be sold to a buyer, quote, if all two principal investment members are in agreement, unquote. That laid the foundation for Amy to proceed forward. It's clear, it's not ambiguous. It could be easier to understand. What does Mr. Giddings say? He says, well, this sale is not to be governed by the business plan. The business plan can be interpreted in two ways. It can be interpreted fairly and reasonably, and its intent given effect. Or it can be interpreted in a manner that Mr. Giddings wants this court to do, and that's to be fraudulent, to oppress and deceive. He says, don't pay any attention to the business plan. It makes no difference. We're not going to obey it. He's been doing that from the very get-go on this entire transaction. The important thing is, Your Honor, that plaintiff relied upon the business plan. It created the entire motivation for her to move forward and open a cafe shop in East Lansing. She contributed or loaned over $150,000 of her money to the company and to Mr. Wan. In contrast, Mr. Wan contributed only $15,000, far less. She was going to be 90% owner. She was going to have 70% voting authority. She was going to have the role of manager, of president, of owner. Over a short period of time, she was quickly squeezed out of all of this. She now is being told she is not a manager. She's being told she is not a majority owner. She's being told she has effectively no voting rights. She can't decide what happens with the company. She didn't do this on her own. She did not walk away. She was forced out. She was never given financial statements. She was never allowed to participate in management. We prepared a lengthy complaint that we filed that go into detail about all the oppression. And I don't have time, and hopefully this court does, to read through the complaint and explain why she is being oppressed. We have numerous counts of what happened to her and was beyond her control. The business has never been profitable. The reason we believe it is not is because we have identified suspicious personal expenses charged to the business. There are unexplained cash withdrawals. There are unaccounted for expenses charged to the company credit card. There are unexplained large credit card payments. And there are numerous other discrepancies. We have asked for accounting records. We are told there are none. This has been shocking to our expert, who says this is unbelievable that there are no accounting records to support anything. We have asked for legitimacy. Show us why these are business expenses. We have received nothing. On top of this, Your Honor, we have been promised financial reports on cost, accounting, and everything else. We find that even tax returns have not been properly prepared and filed. So it's for this reason, Your Honor, that we believe there is even more reason why there must be full accountability and transparency in the bidding process. Plaintiff is here today because she wants the company to try to get more money. In October of 2020, defendants wanted to sell the business for $52,000. Plaintiff objected and said, we can get that. Plaintiff was right. Today, plaintiff is right again. The company can get more, but refuses to do that. We can get at least $40,000 more than it could have been before. In April 2021, when the defendants wanted to sell the business for $91,500, again, plaintiff said we could get up to $100,000. This happened before. There was another occasion earlier this year where it was apparently one offer made, but more could be accomplished. So we asked, can you please open up the bidding again, which the company did. We see no reason why it can't be done today. Why not allow higher offers? There's another conflict of interest that we point out in our reply brief. The company was out of business, was not making any money, and was delinquent of $8,434 in rent. Instead of paying $8,434 in rent, the two oppressing defendants, Chow and Choo Choo, paid themselves $7,500. they could have kept the company's premises going. Instead, it's now being evicted. They stand to lose $22,000 in landlord's attorney's fees, which we have never agreed to. They stand to lose $164,000 in remodeling fees, which would have been retained if the company had paid their rent. There's a clear conflict of interest because defendants voted to pay themselves $3,000 each month until the business sells. So
well, Mr. Zitlow, the subject of these motions, though, is the sale. So, your motion to uphold voting rights is asking the court to rule that the plaintiff has a voting right to stop the sale. And the corresponding motion to confirm the sale of Formosa is the argument that there is only a majority of members that are required to approve the sale, and the sale should be approved. So I do have other things on my docket this afternoon. It would help if you could just focus on the issue at hand.
Thank you, Your Honor. I will move directly to that at this point. Your Honor, we believe, as Mr. Giddings originally represented in email, that 7.3 requires unanimous consent of all members. Unanimous consent is required in 7.3, and it's important because, number one, it says, notwithstanding any other provision of this operating agreement. So 7.3 is paramount. It is intended to supersede any and all other provisions of the operating agreement, including Article 6, 6.1, 6.2, 6. Anything. It's paramount, notwithstanding any other provision of this operating agreement. Second, 7.3 is captioned limitations. So it's intended to be a limit on the power or abuse or discretion of a manager. It says that members have the right to have a say in all major decisions regarding the company, including number one, or in 7.3b, a sale of the business. So if there's a sale of the assets, 7.3b requires unanimous consent of members. I'll read 7.3. It says, sale cannot take place except by the unanimous consent of all members with respect to the sale of all or substantially all of the assets or property of the company. That's very clear. And it supersedes 6.1 or 6.2. And it's intended to prevent abuse by managers. And we believe that's particularly important here because of what I've previously said. Information is being withheld. It's not a transparent bidding process. Even if you disregard 7.3b, 7.3g applies. It says if there's any change in the business and affairs of the company, the unanimous consent of all members is required. This is certainly a change in all business and affairs of the company. It basically puts the company out of business. So unanimous consent is required, notwithstanding 7.3b or 6.1 or 2 under 7.3g. Further, Your Honor, 7.3h of the operating agreement says that if an act occurs that makes it impossible for the company to carry on its ordinary business affairs, the unanimous consent of all members is required. Again, a sale of all assets is something that makes it impossible to carry on the business and affairs of the company. Therefore, under 7.3h, unanimous consent is required. In addition to that, section 7.3L says that if there's a violation of the operating agreement, there must be unanimous consent. We submit, Your Honor, the best interest of the company is to go and ask for a higher bid, up to $100,000. We believe it's bad faith and unreasonable not to do that. Why not try to get more money? Clearly, it's something that's in the best interest of the company. And in addition to that, Your Honor, section 9.2c of the operating agreement, if there is anything that winds up the business or affairs of the company, the unanimous consent of all the members is required. So whether you look at this as a business sale of assets or something that is a change in the business or affairs or something that makes it impossible to carry out the business affairs or something that's a winding up of the business, all of these provisions read together clearly indicate unanimous consent is required. How do you?
Okay, thank you. Thank you.
Excuse
I'll
me.
hear- What?
May I have your permission to supplement some of the information that Mr. Ziello has not yet said?
No, I'm sorry. I asked who was going to speak for the plaintiff, Mr.
Yes.
Zippo was, and I've heard from the plaintiff. I hear from the moving party, I hear from the opposing side, which I've just done, and then I give the moving party a chance to reply and rebuttal. So I'll turn to Mr. Giddings. I've given you a lot of time, but I don't have all afternoon, and you have 2 other motions yet that I have to rule on. So, Mr. Giddings, rebuttal.
Understood.
Your Honor, I will be brief. With all due respect to Mr. Zietlow, he has patently misrepresented my emails. I noticed, I listened carefully, and he tried to suggest that with the sale of the assets, it requires unanimous approval. His emails refer to the sale of the business. So one cannot sell the membership interests in the business without being unanimous. And that's what my emails referred to. Not one of them referred to the sale of the assets. Not one single one is
Okay.
a blatant misrepresentation of those emails. He goes on and on about what's shocking to experts. We don't have affidavits. We don't have a lot of history here. We've got an operating agreement. This is not a dissolution because that's covered under Article 9. And this is not a question of action by the members, which is all of Article 7. 7.3 and all of its subdivisions deal with one thing, and that's overseeing the conduct of managers. The pertinent one is Article 6, quote, voting of members. And these 2 meetings were both called as meetings of members, not managers, no one else. That's exactly what this is about. So we can complain all week, but
Thank
what
you.
governs?
Thank
I'm
you.
sorry.
Thank you.
All right. Thank you.
First of all, although everyone's gone far afield today, I just want to say again that this is the defendant's motion to confirm the sale of Formosa assets and the plaintiff's corresponding motion to uphold voting rights. The plaintiff is requesting the court rule that she has a vote that can preclude the sale, that can hold off the sale. And the flip side of that is the defendants are saying that the terms of the operating agreement only require a majority of the members to vote, and that vote happened and there was a majority that voted for the sale. So the issue is really very clear cut. Even in the brief, at least in the reply brief or the response, I can't remember which, defendant did try to focus this issue on the proposed sale and not on the litany of complaints that the plaintiff has about the organization and the management of the business. And those complaints are certainly part of this case. But today is not the day where it's decided whether those complaints are valid or not valid, because that's not the issue before the court. The issue before the court is whether or not there was a valid vote of members to sell the business. Does it require a majority or does it require unanimity? I also agree that the business plan does not govern this issue. And I most strongly urge everyone that the attorney's emails do not govern this issue. So what governs this issue are, as far as the voting requirements, are the Michigan Limited Liability Company Act and the operating agreement. And actually, since the act defers to operating agreements, and in this case at least, it really is the operating agreement that governs. And a determination is needed as to whether the operating agreement actually is consistent with the act and that it only requires a majority vote, or whether it goes beyond that as the act would allow it to do and requires unanimity. I would remind everyone that although no one's mentioned it, the rules of contract construction do apply to interpreting operating agreements. And some of those rules that are pertinent here is that the court has to examine the entire document as a whole and not just pull out isolated sections. Also, if the language is unambiguous, like a contract, it has to be applied as written. And finally, even seemingly conflicting provisions should be reconciled and made consistent if they can be, without doing violence to the plain language or the court writing a new contract for the parties, because none of those things are allowed. So with those rules in mind, at issue here is section 6.2 that requires a majority vote, and section 7.3 that requires a unanimous vote. And again, the plaintiff says the unanimous vote is required, and the plaintiff's rights in that regard should be upheld. The defendants say the majority vote applies and that the sale should therefore be confirmed, because no one really disputes or can dispute that there was a meeting on April 9th, I believe it was. There was notice of that meeting. There was an opportunity to be heard, and there was a vote. And the majority vote was to sell the business. So turning back to the article, or to the operating agreement and section 6.1. Section 6.1 is, of course, in Article 6, which is entitled Voting of Members. And 6.1 provides that all members are entitled to vote on any matter that's submitted to a vote of the members. And it specifically lists the members shall have the right to vote on all of the following. And one of the items listed is the sale, exchange, lease, or other transfer of all or substantially all of the company's assets other than in the ordinary course of business. Then 6.2, entitled Required Vote, says, unless a greater vote is required by the Act or the Articles, the affirmative vote of a majority of the shares of all the members entitled to vote on such matter is required. Then we have Article 7. Article 7 is entitled Management, and it goes directly to the powers of and the authority of the managers of the company. 7.2, entitled General Powers of Managers, has certain matters that any individual manager has the power to do on behalf of the company. And one of those is each manager has the power on behalf of the company to sell, convey, mortgage, grant a security interest in, pledge, lease, exchange, or otherwise dispose of or encumber any real or personal property. Now, 7.3 has limitations, and these limitations are specifically on the power exercised by any manager on behalf of the company. And for that, there is unanimous consent of all members required. And one of those is the sale of all or substantially all of the assets and property of the company. I do not see these two provisions, the 6.2 requiring a majority vote and 7.3 requiring unanimity, to be conflicting. I think they can be read consistent with each other and consistent with the document as a whole. And that is that the 7.3 requirement on voting applies to an act. It's a limitation on the action that a manager takes by himself or herself on behalf of the company. And for that, unanimity is required. But Article 6, which pertains to the powers of all the members to vote on matters submitted to them, requires a majority of all the members entitled to vote. This matter of the sale was submitted to the members as a matter that the members were entitled to vote on. It was not an act of a manager taken solely by a manager on behalf of the company. And for those reasons, Section 6.2, a majority of the members entitled to vote is all that it is required. So for those reasons, the defendant is entitled to confirmation of the sale. There was a majority vote undeniably to sell the business. And the plaintiff's motion to uphold voting rights, which is dependent on section 7.3, which is not applicable in this situation, has to be denied, as well as the plaintiff's request to enjoin the sale, because the sale was properly voted upon by the members, and the majority of the members voted in favor of the sale as required by section 6.2. So I'm granting the defendant's motion, denying the plaintiff's motions. And that takes us to, I still have, although I had no response to it, I had the plaintiff's motion for leave to file a second amended complaint. Did you want to be heard on that, Mr. Zitlow or Ms. Potts?
May I respond? Your
Yes.
Honor, may I respond?
Yeah, I mean, normally I would have them move first, but go ahead, respond.
Well, we don't have any objection.
Okay, then the plaintiff's motion to,
The plaintiff's motion to amend the pleadings, of course, as the court is well aware, the court, there's a great latitude in terms of that. We have our own motion to amend our pleadings by adding a counter claim, although frankly, when they amend theirs, we'll be responding with an amended counterclaim most likely
Right.
anyway.
Right.
We have no objection to their amending.
okay, very good. Then I'm granting the plaintiff's motion for leave to file a second amended complaint. And then I still have, although this goes back to the beginning of June, but I have the plaintiff's motion to compel. Did the plaintiff want to be heard on that?
Yes, Your Honor. We had asked for information that still has not been provided, and that the defendant's claim is privileged. They do not assert why it's privileged. It's being performed on behalf of the company, and as a member, the plaintiff is entitled to all information pertaining to the company. We had asked for all email communication with Catherine Susanto, all email communication with her attorney, John Fraser, and that was labeled privileged and confidential, but we don't know why. There's no explanation for that. We also asked for bills received by the company from attorneys. We want to know what expenses the company has with respect to attorney's fees. That was labeled privileged. I don't know. There's no reason why it's labeled privileged. It's certainly an expense of the company that we've never known about or approved. We asked for tax returns of the oppressor defendants. We want to know what they have received from the company and how they are treating that. That was denied as private and confidential. We believe, Your Honor, it is discoverable because it will lead us to tell what there are, what transactions there are, potential conflict of interest, and interpersonal transactions between oppressor defendants and the company. We also asked for communication between attorneys James Giddings and Marcus Balberry, between the company and them, and that was declined as privileged. Again, no reason why that is privileged. It's not attorney work product. It's not prepared in contemplation of the litigation, and any information that the company has is open for discovery anyway.
All right, thank you. Mr. Giddings, response?
Yes, Your Honor. I think if you looked at our response, this motion is out of order. It's premature. The rules MCR 2.310 and 2.309 are clear, again, and unequivocal. In offering this motion, the moving party, quote, must state that the movement has in good faith conferred or attempted to confer with the party not making the disclosure in an effort to secure the disclosure without court action. That's 310. And the other 309 says essentially the same thing. Mr. Zitlow never picked up the phone, never sent any communication. We'll be most happy to sit down with him and discuss what documents, and we'll supply, we've supplied already a significant number of documents. And if that's not satisfactory, we'll sit down with him. And then if we can't reach some resolution, the next step, as contemplated by the court rules, is to bring the matter to this court. But this motion is premature and really inappropriate until he has made that assertion, and that assertion is not contained in his motion to compel.
Okay, well, I'm familiar with the rule that the defendants refer to. But the rule doesn't say that I can't hear or shouldn't hear or will not hear the motion to compel if it hasn't been complied with. The rule usually causes some ire among judges when it's not complied with. But again, there's nothing in the court rule that says it's a bar to bring in the motion to compel, or it's a well, I mean, it does say it's a prerequisite, but it doesn't make it a bar that the court can't hear it. This has been pending for quite some time, this motion, that is. It would seem to me that, even if it's not the defendant's requirement to pick up the phone and have the conversation, that could certainly have been done in order to resolve this. I'm only considering, though, the things that were specifically brought up in the defendant, or in the plaintiff's motion, rather, as being deficient, and that is request for production number 3, which asked for receipts, invoices, purchase orders, canceled checks, credit card statements, and documents for all the expenses on the tax returns for 2018, 2019, and 2020. The documents that were provided were 15 credit card statements for the last 3 months of 2019, and I believe all of 2020. And the plaintiff is complaining about that. It is unclear from looking at the response if the other items exist or not. If they don't exist, then all that's needed in response to the request for production is for the defendants to say that these don't exist, so that the plaintiff can have that as a matter of record in response to request for production number 3. So the defendants need to do that if that is the case. Request for production number 20 and 21 ask for accounting records. The response is, according to the plaintiff in their motion, that the response is that there aren't any, but the written response attached to the motion refers to exhibits B and D. So again, I don't know what B and D are, but if there were accounting records that don't exist, then the defendant just has to say so, that they don't exist, so that the plaintiff, again, has that as a matter of record in response to request for production number 20 and 21. With respect to request for production number 6, the request is for communications between the defendants and Catherine Susanto. I believe she represents she's the purchaser, the proposed purchaser. The plaintiffs say in their motion that the defendants refused to produce those items, the communications. But the answer that the defendants responded with says that there are none. So the defendants have sufficiently answered that by saying that there are none. Request for production number 7 requests communications between John Frazier, who's the attorney for Ms. Susanto, and the defendants. And the response is that the communications are privileged, but the attorney for Ms. Susanto is not the attorney for the defendant, so it is unclear how that can be privileged, and there's been no support for that. So I would compel request for production number 7. Request for production number 22, the individual defendant's tax returns was objected to in that it is confidential and irrelevant. If we're going to fish into defendant's individual tax returns, then the plaintiff's going to have a much better reason than what the plaintiff has provided today, or in their motion, that it would show gaps in the company's records that might be existent in the individual tax returns. Those are confidential, and there's been no relevancy shown for the individual tax returns. So I would not compel an answer to that. But I will grant the motion to compel the responses, as I've indicated, to request for production number 3, 20, 21, 6, and 7. And that would be within 14 days from today, Mr. Zitlow, if you want to prepare an order that says that.
Thank you, Your Honor.
Excuse me, Your Honor, may I ask a question? Yeah, you said number 3, 20, 21, and I didn't hear the last one.
6, did you get that?
6, number 6?
7, yes, 6 and 7.
6, did I hear number 3 there someplace? Or
Yes,
no?
3,
3, 6,
21.
3, 6,
Let's start over, okay? 3, 20, 21, 6, and 7.
6 and
And I'm-
7.
Yes, and I'm saying no on 22.
All right.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
I need you to all sign off because I have another hearing and I'm waiting to let them in, please. Thank you.
We're trying to figure out how to sign off, Your Honor.
Okay, I can remove you then. I know, because that some people aren't
Yes,
familiar with
remove
that.
us. Please
I'll just
remove us
remove you.
without ado.
Don't take it personally. I'm just removing so I can do my next hearing. Just waiting for everyone to get connected. Okay, looks like we have everybody. This is People of the State of Michigan versus Andrew McClellan, docket number 17-926FC. And this is the time set for a show cause on a probation violation. And Mr. McClellan, it is alleged that on or about June 28th of this year, you failed to engage in the MRT programming at PATS as directed. Do you understand the allegation against you?
Yes, Your Honor.
If it's proven true, it could subject you to a maximum penalty of up to 20 years in prison based on your original conviction. You have the right to be represented by an attorney. You are represented by Mr. Austin. You also have the right to a contested hearing where you could appear by yourself or through your attorney. You could hear the evidence presented against you. You could cross-examine witnesses and you could present your own evidence. And Mr. Austin, can you tell me how we're proceeding on this?
Yes, Your Honor. It's my understanding Mr. McClellan wishes to plead not guilty to the violation and request a hearing.
Okay, then let me see what I can do about a hearing date.